Here's a quick overview of what I wanted to talk about today. Electronic signatures are relatively new, and a lot of us are using it. Do all of you use electronic signatures in some fashion? Are you using them yet, Fred, like DocuSign? Okay. At some point you may, and so I'll try not to bore you with it, but there's some important considerations. Some of it's just very simple stuff, but you have to think a little differently about how you use electronic signatures. So we'll discuss that for a couple of minutes. And I also want to spend a few minutes talking about procuring cause and arbitration issues. That has struck close to home on the Difanis team recently. And lastly, post-inspection agreements, and that also comes right out of this week's misadventures in real estate from Team Difanis. Do you guys have any specific areas of interest that you wanted to discuss in particular? Nothing? Okay. Electronic signatures, so we'll start with that. So, other than Fred, is everyone else in here using DocuSign or some other platform? You are not yet. Okay, so I was not a super early adopter of DocuSign within the office, but we've all started on our team using it in the last, 2 or 3 months. So DocuSign, the big advantage is, who's been victimized by like the .loop platform that Keller Williams is using locally? Yes? Did you feel victimized? Because I've felt victimized when I've received documents on. Yeah. Because, okay, so to set the stage with what that looks like, that's a complete sort of comprehensive online transaction and document management platform. It's not merely for electronic signatures. So if you get a notification, in my case, that there was an offer received, you have a link, and you're linking into this .loop, I think is what it's called, site. And then you have to create a login. But if you're not a paid subscriber, you don't have privileges for sending documents that way. You can merely access them. And it sort of, if you kind of know to look for it, will let you export it as a PDF, because when I get that, if it's an offer, what's the first thing we want to do? We want to send it to the client, and I don't want to send them into this confusing maze of document management website stuff. So the first thing I want to do is get it as a PDF so I can do what we've been able to do for years with a scanner, hit forward and send it to the client as an email, and it made it very difficult to do that. And some of the files, because normally the contract, in fact every time I've seen it, contract was separate from the disclosures, and the disclosures weren't together, it was 3 or 4 separate files. And some of them would let me save to PDF and email, and some simply wouldn't. It was throwing an error message every time. And so finally, in the last one of these that got done, the agent who had initiated the .loop process ended up giving up on it. As I pointed out to my client, that agent, without a car, could have walked back and forth between the client and my office and probably to my out-of-town sellers in Texas, and the length of time it was taking us to get it straightened out electronically. I mean, it was a colossal waste of time.
Are they still using .loop?
That was as of 2 weeks ago.
They are all moving to it over there. And actually, Remax now has a way to sign up for it. And
they are, I think .loop was at the trade show display at the convention, but so far as a victim of it, I'm not impressed. I'm more interested in now. So I think having a full platform for transaction management electronically would be nice. So I'm sure there are some redeeming characteristics, but I'm fairly techno savvy, and so when I'm on the receiving end of it and I find that it's wasting 10, 15 minutes of time just to figure out how to access the stupid thing, and once I've gotten my eyeballs on it, it takes me another 20 or 30 minutes to figure out how to get it in the hands of my client, and then once it's in the hands of my client, I think only the initiating party can set it up so my client can sign it. So DocuSign, just by way of contrast, DocuSign is not a comprehensive transaction management platform. It is just a platform for obtaining electronic signatures. Completely cross-platform compatible, and by that I mean any type of device that has a web browser. So whether it's an Android device, an iPhone, an iPad, a PC, or a Mac, any of those types of devices are able to use DocuSign. And you see it displayed on screen, and if you've never used it before, I had an 80-plus-year-old widow that turned around a price reduction form via DocuSign, having never seen or used it before, in like 5 minutes a couple weeks ago. So when I'm struggling to navigate through .loop and it's wasting half an hour of my time, and my 80-something-year-old seller is getting a price reduction turned around via DocuSign in 5 minutes, that sort of tells you something about the usability of it. So DocuSign, if you initiate it, when you sign up for it, what you're doing is uploading your PDF file that you need to have the signature slapped on. That can either be an original PDF, like our original contract form that you would fill in the blanks, or it can be a scan. So if you don't have the full version of Acrobat, or if you're not using a PDF utility that will let you fill in all the fields and then save it with the fields filled in, when in doubt, you could even handwrite in the fields, scan it to PDF using one of our network scanners. Once you receive it, you save it on your computer, you upload it to DocuSign, and then from within DocuSign, all you're doing is you enter by name and then by email address all the recipients, everyone who's going to be in the chain who needs to sign it, and then all you're doing is dragging and dropping all the spots where you want initials or signatures. It works great if it's a contract where all you need are initials and signatures. I can tell you from early experience, it is much, much more cumbersome to use if you're trying to get something turned around like listing documents. And the reason for listing documents being more confusing is because of the nature of some of those forms, specifically the disclosures. Because if it's a contract that needs initials or signatures, those aren't optional. You've already discussed with the client what you're about to send them, and you have very specific spots where they need to initial, and it's not optional. They're going to initial here, they're going to sign here, they're going to then initial here. And as they click through it, it will not let them get past it. They either initial it or they don't, and the document doesn't get completed. So then it's virtually idiot-proof. But with disclosures, we have to make it optional. Do not send them one that has pre-selected for their convenience no on all the Illinois residential real property disclosure defect questions. No, you are not aware of, Mr. and Mrs. Seller, all of the following. Click, 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 click. So then you have to go in, and not only do you have a whole bunch of blanks you have to assign, you can do checkboxes. I mean, DocuSign has the capability of working with all of those forms. So the most common things we'll use are slapping an initial field or slapping a signature field, and you're just dragging and dropping them to right where you want them on the paper-based document. With the disclosures, you can do it, but you're dragging and dropping optional check marks in pairs to times 23 questions, then on the other disclosures as well. And they all have to be optional, which means the client can click through it without filling that part out, and it doesn't flag an error. So just a quick overview. So it's great if you need a contract signature. I would still at this point encourage you to probably look at doing either in-person meeting when possible or returning by scanning to email with listing documents. But if you choose to use DocuSign, just be aware that's going to be the weakness. That's what we've run up against repeatedly, where Tracy has become fluent in it. But it's returning listing documents where time after time after time, hey, the disclosures didn't get filled out properly. They signed it, but the questions are blank. The other DocuSign issue to be aware of is how many of you have received an offer ever that has the offeror's information filled in and has left your client and your side of it to be filled in by you? Everyone. If you're not raising your hand, you're lying. Everyone. And that's fine when we're dealing with paper-based copies, because if we're adding the informational stuff at the top of page 1 after the fact, after it's been circulated, are we changing substantive terms of the contract when we're doing that? No, we're just filling in information. And so that doesn't legally jeopardize the integrity of the contract. But when you're thinking in terms of electronic signatures, part of what makes that valid is that Acrobat and DocuSign, so DocuSign works with a built-in feature in Acrobat, will electronically validate that signature. In other words, it's kind of like the police having to track the chain of custody of a piece of evidence. And so electronically, if it's made the rounds via DocuSign, one of the things that DocuSign is doing is confirming that no changes have been made after those signatures were affixed. And if you think in terms of just electronically, yes or no, has this document been digitally molested? If you're thinking in those terms, DocuSign doesn't know if you've just added in the brokerage name and agent name and that party's attorney after the price and closing date have been tweaked and agreed upon and initialed by the parties. And since it doesn't know the difference, if you make those alterations, number one, it's a little more difficult to make them. If you have the full version of Acrobat, you have to extract the pages first and then annotate them. But if you make any of those changes, it invalidates the electronic signature. So that means if you're doing DocuSign, you'll want to make a point early in the process of getting, even if it means from the other agent, because they didn't fill out all of the informational part at the top. Because we've been on the receiving end of documents where not only do they expect us to fill out our side, which makes sense, but they didn't fill out all of their own side properly as well. Make sure before it makes that round, the final round for signatures and initials and DocuSign, all that top of page 1 information, both of those buyer and seller sides, are filled out in their entirety, because once it gets the last signature or initial via DocuSign, you don't want to make any changes later. If you do, and you have a final PDF that you scan in, that will not have those signatures electronically validated. So then what you're going to see is a non-handwriting signature that came at either the poke of an iPad screen or the click of a mouse, but internally the file won't have electronically validated that signature. Does that generally, what I'm describing, make sense to everyone? So if you need to do that, if there is a contract that's incomplete and it's gone via DocuSign, and you add that information later and you scan it, be sure to save 2 versions of the file, because the one that you save freshly after the DocuSign signatures will show that it was valid, and it will show that the basic contract terms were all there, and that final version that you then circulated to the attorneys, for example, that the only change was that you were filling out the mailing address for your buyer or for your seller. Questions on that? Is everyone awake?
I don't have DocuSign. I wasn't in the office when the class and all that was being, proposed and so on. What is the monthly fee, or what is the fee for DocuSign again?
Do you know?
I don't
Anyone in here? That sounds about right.
It's like 8, you said?
$8 or $10.
I can't remember what it was, but I don't know, there was something that was $40 a year.
I think there was an initial sign-up fee as well, maybe. But so here's the way to justify that, or to at least analyze it for whether it's worthwhile. Even if you have a client who's local, where you could go track them down and it's not all that difficult to do, if it's going to take even 30 minutes of your time to get in the car, confirm a meeting time and a meeting place with them, get over there with them, and then get it signed, and then get back, by the time you add up the value of the lost time and the vehicle expenses, DocuSign will often pay for itself with 1 or 2 sets of initials a month.
So it's not a big deal just to get online, sign up, and...
Right. Yeah, it is easy. And like I said, I go back to my 80-something-year-old seller. That's the ultimate proof. If she was able, anyone who can check email on any device can do DocuSign.
Okay.
Cheryl?
Just for everybody's information, I had a foreclosure deal and through Andrea. And the attorney's office is Pearson Associates out of Chicago, who does a lot of those foreclosures.
Will they not accept that?
They won't accept. I had a client in California who had to extend, sent it through DocuSign, got it back to them. They said, no, we want original signatures. So they had to sign it, overnight it, took it to Andrea. I said, Oprah, how are you going to get this to them? She said, I'm going to scan it and email.
Right.
But they won't accept
Right.
an email. Yeah, ridiculous.
And from a legal standpoint, in terms of legal acceptability, no issues. The issue of electronic signature platforms comes up with IAR's legal counsel. I know Paul Espinoza, our representative who comes here once or twice a year from Pearl Insurance to speak, and he was also at the conference and spoke. That's a question he's been asked, because remember, they're the ones, he's not a lawyer, but they're the ones that are defending against the claims, and so they would surely know if there were claims where the validity of a contract was called into question because of electronic signatures. Absolutely no problems at all. No problems with it at all. So legally, is it valid? Absolutely. Can you still get a given party who insists on having it done a particular way? Sure. And it's going to be the institutional sellers, REOs, reload deals, where they'll have some very specific proprietary rule, and it doesn't mean that the way you would have done it was legally invalid. It just means that they have rules that may or may not be based on what's valid. It's just a rule that some bureaucrat over there has to follow. And there's still relocation and or REO transactions. In fact, an agent from St. Louis who just got a big REO contract, we were talking to them, and everything in their document package, I mean volumes of paper, must be faxed. In 2012, all of this stuff has to be faxed. There is no other acceptable method for sending it. Any other questions on the electronic signature stuff? Great time saver, but be aware that you want to be sensitive not to break the validity of the digital signature at the end of the process. Okay, procuring cause and arbitration. The scenario that affected my team recently, but it's also the most common way that procuring cause can come up. is you get a buyer client who does not have a working relationship with another realtor. But how often is a new buyer lead somebody who's never ever seen a house with a realtor? Those are pretty different questions, right? And so the easy way where you can have something come up is somebody shops around for realtors, or maybe isn't even consciously shopping around. It's just that they call the listing agent or they go to an open house, and then that agent talks them into seeing one or two other houses. And then for whatever reason, it may not be that they hated the agent they were dealing with. It may just be that after that, when they got serious about the house hunt, that a relative said, oh, you got to work with so-and-so. And so they come into the office to meet with you, and they answer honestly, no, I don't have an exclusive agency relationship with, nor, if you ask further, nor have I been working specifically or exclusively with anybody. I mean, they'll sound like a complete blank slate, and then you find out later that one of the houses they've asked you to show them is one that they saw with another agent before. So here you have a situation where you're not in violation of any ethics issue. You're fulfilling the obligation that you have under our code of ethics to inquire as to whether they're party to an exclusive representation agreement with some other agent. And yet, you run a serious risk if you subsequently sell them a house that another agent showed them, that you could be on the receiving end of an arbitration request. So, everyone see how that can happen? And so then the question becomes one of procuring cause. So it is entirely possible to represent them, be their designated buyer's agent, hand them their written notice of buyer's designated agent, or have them sign a buyer's representation agreement. Do any one of those scenarios where you do everything you're supposed to do by the book to make clear, both orally and in document trail, that you are their exclusive buyer's agent, and yet when it crosses the hot sheet, some other agent will see a name of somebody they show that property to. Now, we've all seen buyers' names cross the hot sheets to whom we've shown properties, and if it's some property we didn't show them, there is no procuring cause issue there, usually. Procuring cause arguments, there's no absolute hard and fast rules. There's a lengthy list of factors used by an arbitration hearing panel to determine who the procuring cause was and how commissions should be allocated. And they have the right to throw the commission 100% to either party, but they can also split the baby. So they could decide that the commissions are going to be split partially. But as I said, no hard and fast rules. So if you get dragged into arbitration, there's never, ever a guarantee that you're going to prevail. You can always get thrown for a loop, and you can always have the other party, even if you're pretty certain that their facts aren't particularly compelling, if they are simply more pitiful sounding. It's all a function of who's on that arbitration panel and how they choose to evaluate those factors. So with that being the case, I want to sensitize you to the fact, because we had that happen. Somebody on my team closed transaction, did everything by the book, and after it crossed the hot sheet, we were hit with a threat of arbitration. And ultimately, we settled it with a referral fee, and it was a relatively modest referral fee, because I do think that there is a better chance, greater likelihood than not, that the facts of that case would have gone our way. But there was no guarantee the facts would have all gone our way once it was all said and done. And even if they had, we would have cost a significant amount of time and the opportunity cost that goes along with it. In a market that still has challenges, and in a market where most of the rest of the agents in the marketplace outside of our firm tend not to sell nearly as much as we do, the time value to them is not nearly as high as it is to us. In other words, if it derails you from your business and you actually are a busy real estate professional who has other clients and other revenue generating activities in which you could be engaged, it's a whole lot more costly to you to be sidetracked for 10 or 20 hours dealing with the pre-hearing related stuff, getting dragged into the hearing, and then potentially having to arrange for witnesses and or letters and all of that stuff. So 20 hours of your time, if you could have been spending that generating revenue, is usually going to be an awful lot more valuable than the time if it's a non-producer who's threatening the complaint. It's a non-producer where that one deal was going to be their whole year. And you got it, they don't have anything else better to do, and so they don't care if it burns up 20 hours of their time, because their time's not as valuable as yours. So be sensitive to that, because it's one of those things where you'll probably want to tweak the way you ask questions. Brad Coates has an interesting way that he deals with this. He knows correctly from experience that if you ask to satisfy your ethical obligation, are you party to an exclusive representation agreement with another agent? The answer is always going to be no. Well, instead, since we know that in most cases, almost all cases, the person has had contact with some other realtor. So instead he asked the question, so who have you been looking at houses with? What agent has been showing you houses? He just goes ahead and asks a leading question that presupposes that there's another agent, because then they're much, much more likely to say, well, I've had contact with so-and-so and so-and-so, whereas if you ask the question, are you party to an exclusive representation agreement, the answer is just going to be no, and you haven't gotten anywhere. So ask that so it'll give you the ability to see this sort of thing ahead of time. I have another one this week where something along that line is likely to happen, where I know that the house that is the finalist for people who have specifically come to me wanting me to represent them in the purchase is something they've seen twice with the listing agent. As a result, I will almost certainly end up contacting that agent before they make an offer to preemptively offer a referral fee. And remember, as you're thinking through the variables, if that buyer client was not willing to do dual agency, and if that agent was going to treat it as dual agency, they can't refer it and make money unless that's disclosed and consented to by the party. So I mean, their alternative, if they don't say yes to the referral fee, number one, hopefully you'll look like a hero by preempting it and saying, because before the offers come in, before they even know maybe that person's not working with them, much, much more likely then to have that situation viewed favorably. And hopefully, especially in those cases where somebody walks in the door and already kind of knows what they want because they happen to have seen it at an open house or they've had the listing agent show it to them twice, that listing agent's still going to get paid well. They're going to get paid a fraction of the other side in addition to their listing side. And hopefully the referral fee is still easily makes the remainder of that transaction side worth having from your standpoint. No hard and fast rule there, no absolute requirement that you do that. Just food for thought and a suggested practice, because the alternative is somebody gets ticked off when they see it cross the hot sheet later, or if it's the listing agent, him or herself, they'll know as soon as the offer comes in. And it may actually disadvantage your ability. I mean, they may start digging their heels in, even if it's subconsciously trying to fight you on getting the deal done because they're so mad that they think you stole their client, even if you didn't.
If you were going to arbitrate, is it better to do it before it closes or when it comes across as a sale pending? I mean, if you were going to approach the other agent, as an example.
If you thought you were owed a commission, is that what you're saying? The general rule is you want to facilitate it closing for two reasons. There's nothing to arbitrate if it doesn't close,
Right.
and you don't want to be liable for interfering with the sale. Number one, you don't want to be liable to the other agent for interfering with a transaction of theirs or with a contractual relationship that they may have legitimately established, because as I said, the procuring cause argument is completely separate and apart from whether there was a valid buyer representation agreement or various other types of contractual arrangements made. So you don't want to put yourself in the position of potentially being liable for injuring the other agent, and you really don't want to do anything that could later be interpreted as having put up any roadblocks or barriers to getting that party into the house that was the best fit for that buyer. And so with that being the case, almost always the best course of action is let it close. It doesn't hurt to possibly, depending on the circumstances, when in doubt, go talk to Bill about it, come talk to me about it, but it wouldn't necessarily be a bad idea to put the other party on notice that there is an issue and it may be something you'll want to arbitrate. But then again, you may not. On the one hand, if you know it because you saw it cross the hot sheet and it's not closing for 45 days, it's a lot more frustrating for the party who may not have done anything wrong, but where you may still actually validly be the procuring cause. It's frustrating because you don't want to ambush them after closing when they've gotten the paycheck and the money may already be spent, and then you hit up that other brokerage claiming that you are the procuring cause. So if you think that you're going to cause an obstacle to the transaction even by giving the heads up, then it's possible that you may not want to give the heads up and just lay low until it closes. But I would say that's a Bill or a Matt question if you see something like that cross the hot sheet. But our top priority has to be don't get between the client and the best house for them. If you think that there's a commission obligation that is owed to you, make sure that we deal with that separately in a manner that doesn't interfere with any of those other relationships. Because in the course of pursuing that, which may be just and righteous on your part, you don't want to run afoul of other issues. Yes?
So what do you do in the case when a listing agent has shown a property to someone, that person, actually that client, isn't really hip on the idea of doing a dual agency, and they contact you to, you know, show the house and be their agent on that side.
If it was just that property and the agent, the listing agent, you know, had to disclose up front, or it was clear because their name was on the sign that they were the listing agent, not the buyer agent, I think it's possible that whatever agent landed them, as long as the listing agent didn't place it as a referral. You know, obviously there's a situation where the buyer says, I'm not going to do dual agency, I want my own agent, can you find me somebody? And with the consent of that client, the listing agent places a referral and gets some sort of a split from the selling side in addition to their listing side of the deal. But if that buyer has done a couple showings with the listing agent and then realizes, either because they knew all along but they weren't going to have their own agent until they got to the point where they'd found the house, or because somebody told them, or because they just felt uncomfortable, hey, I don't want to do dual agency, I don't want to have somebody who either has a conflict of interest and can represent either party, or who has to only represent the seller, if they land in your lap, I think it's certainly possible that you'd have, having sat on arbitration hearing panels before, and I'm about to do one here in a few weeks, if it becomes clear from testimony that there is no way that buyer was going to get to closing with that listing agent, that certainly can weigh heavily in favor of not deeming that agent was procuring cause and entitled to the selling side commission, but it's still not a guarantee. And so you can choose to proceed and not make any sort of a preemptive offer of a referral fee, but that's where your own business judgment has to come into play. If you think that there's a chance that you're going to set off a time bomb, or that the other agent's going to get in your way and try to scuttle the deal, if you haven't already just sort of cleared the air up front by saying, hey, I just wanted to give you a courtesy call, let you know that this person who I know has seen this property with you once or twice is now working with me. They wanted their own dedicated buyer agent. The house they want is the one you have listed, and for whatever reason they've just decided they're not comfortable with that situation, and then offer them a referral fee. It's awfully hard for the other party to say no. So you could potentially get to closing and the other party might grit their teeth. They may just let it roll off their back and not mind at all, maybe. But I will tell you personally, when I've been in that situation, and it's happened with somebody in our office here in the last year or two with me, and it's probably going to happen here in the next week or two with somebody outside the office, I'll call them preemptively and go ahead and offer them a referral fee. It's a small enough market, we're going to live to see them again someday, that other agent. So no hard and fast rule. I'm not telling you you have to do it that way. Just wanting you to be sensitive to the variables and how those procuring cause issues can play out. And there's nothing more frustrating than getting to closing, having the paycheck in the bank, or having briefly been in the bank and then having been spent, and then having somebody else hit you up and want you to cough the money back up. So the line of questioning with the new prospect is important, because if you're doing the Brad Coates technique of, hey, just tell me which realtors have you been doing showings with, or who's shown you houses so far, you're way more likely to be able to get an early heads up that there's a scenario that could potentially subject you to a procuring cause issue. Max?
And then I think the next question after that, if you discover that they've been working, and I would just ask, what have you liked about the agents, and would you continue? Because at that point, either they are definitely interested in shifting gears, and maybe they don't understand the system,
right?
Or commit them, either commit them to you or commit them to somebody else, because you don't want to spend your time.
That line of questioning is good, because it goes back to the more complete a picture that you as a potential buyer's agent can get in that case, the more prepared you are to head off the complaints of some other agent who says, but I was a procuring cause, because then you're able to say politely, or have Bill Craig say politely to that other agent's managing broker, here's the reasons that this client laid out, where no matter how well you think you had clicked with them, there is not a chance they were going to work with you on that transaction to closing. Not a chance. They didn't understand all the workings of the system, but once they got serious about the house, they knew they wanted a buyer's agent. And I'm sorry that they wasted a little bit of your time, and and you may be open to paying a referral fee. But if you know the answer to the question that Max just raised, then you're able to try to make the case preemptively. There is not a chance you would have gotten that deal closed. It was not going to happen, so you got to let go. And we all know what it's like to be on the other end of that. We're all on both sides of that process, so a little empathy can go a long way. Other questions on that? Post-inspection agreements. Some of this will be a little heads up as to what's changing on the new contract. Quick contract update. We had our 75th meeting of the Champaign County Association of Realtors Contract Working Group, joint meeting with the Real Estate Committee of the Champaign County Bar Association. Made a couple of what are supposedly final changes. I think we really are done with it. It seems to be on both the attorney side and the realtor side. No one wants to consider any further changes. So that's good because it coincides with the point at which all of the participants' will to live has been eroded to next to nothing. So I don't think there's going to be any more changes to the contract, but the rollout is still going to be probably 2 or 3 months away. We were originally, 14 years ago, whenever the last one was rolled out, we did an in-person session where the attorneys kind of ran through an orientation, did a Q&A. That requires, though, that you do that multiple times and that you do mandatory in-person attendance at CCAR, which is really difficult to accomplish. And the other thing it doesn't do is there's no provision then for a new member coming in to get trained on it the way that the attorneys trained the existing members during that sort of one-shot orientation. And so with that in mind, my working group had wanted to do a video so that it would be immortalized and new members could get the benefit of the same training that existing members get. The attorneys were okay with that, but what they didn't want, they were okay with the scripted orientation being immortalized in video. They didn't want a live Q&A where they might be stuck answering questions on the fly. They didn't want that part immortalized, so that was fine. So the attorneys were going to present it. Now the attorneys are not going to present it. Now the attorneys are willing to write a script for the orientation presentation, and they're willing to have it on video, but only with third-party hired talent delivering the orientation. So if anyone knows of any really good, preferably easy on the eyes actors or actresses that are good at reading a teleprompter and going through an hour of CCAR MLS contract orientation, we're open for names. What we're probably going to end up doing is trying to find somebody from the U of I who's journalism or some acting related field where they can at least be reasonable to look at. Yes?
Tell me about, since it has taken a couple of days to get to the contract, getting it out, technology. Is there anything in the contract that kind of allows you, it says
nope.
You can use electronic signatures?
Nope. Well, it has always said that facsimiles will be deemed valid as an original, but when it comes to notices, certified mail, carrier pigeon, Pony Express, still got to use one of those.
Upgrade that because
Nope.
Today's
Nope.
because emails can be tracked.
Nope.
Personally, between you and I, what would be your opinion of that?
I don't object to keeping the certified mail requirement, and here's why. And a lot of people I don't think realize how useful that provision can be. The contract doesn't currently say you have to certify mail it. What the contract says is notices shall be deemed valid when either actually received by the other party or as evidenced by a certified mail receipt. And so here's the deal. The certified mail receipt basically is your get out of jail free card. Whether the other party ever saw the thing or not, if you have a certified mail receipt that shows that was dated on or before the deadline for service of that notice, that is, as far as the contract is concerned, all the proof you need that it was properly served. Whether they got it doesn't matter. You have the absolute proof it was properly served and that your client didn't waive any rights by missing a deadline. The whenever actually received part, you can have very strong circumstantial evidence about that, but in most cases, if the party has their own attorney, I guess the one exception would be is if you were a dual agent working both sides, you could have the email chain where you sent the post-inspection notice that came from the buyer side of it to the seller, and the seller sent you an email reply saying, yep, got it, we're reviewing it tonight, and that would be your proof that it was actually received. If you've got two agents involved, then you're not going to necessarily be in receipt of that. So, speaking for myself, since the only absolute way to guarantee that you're not going to be accused of having missed the deadline is certified mail, I will skip the certified mail step if and only if I have very strong proof positive that they did actually receive it. And the easiest example of that would be a counter offer on the post-inspection stuff. Or now that the inspections aren't taking as long, if you're somebody who wrote an offer last week that allowed 3 weeks for the first inspection deadline, you got a home inspection scheduled 10 days later, you got your notice served a whole week inside of that first deadline, and you had a post-inspection agreement fully executed before deadline number 1 had come to pass, no need. Don't worry about certified mail. Or if you have gotten a substantive counter offer that either was initialed by the other party, which would be best because then it would be a written counter proposal, or if you had simply gotten a forwarded chain of emails where it was clear that that other party had proposed this in the alternative, then that is very, very strong proof that it was actually received. So if you are satisfied, and this is, again, not a hard and fast rule, you just have to be satisfied to the point that you think there is no possible chance a certified mail receipt would be needed to prove that you did it. You have to be confident the other agent's not going to claim notice. What notice? I don't remember any notice. So if you have what you would deem proof positive that they actually received it, you can skip certified mailing. But the convenient thing about the certified mailing step for our purposes is, as I said at the beginning, it does not matter if they actually received it or not. Even if they never got it, your having a copy of that receipt in your file means, doesn't matter, we served our notice on time, I don't care if you saw it, we didn't get an agreement, my client wants out, and you can't claim that we didn't get the notice to you in time. So it's not changing, but it's not all bad. It would be a slightly different matter if the parties weren't always represented by their own realtor, and the attorneys, to their credit, don't want to impose upon realtors the same liability that attorneys take on for being able to speak for their clients. The new contract will, by the way, have an additional bit of verbiage in the notices paragraph to explicitly state what the attorneys have said for years, which is notice from realtor to realtor shall not be deemed valid. This new contract explicitly states that. Realtor to realtor means absolutely nothing. You have to have the certified mail receipt, or you have to have proof positive that the recipient party actually got it. Yes?
This is on the post-inspection. What is the correct way? I know you've explained it before, but you have A, B, and then there's C.
With 2 options.
Yes.
Okay.
I don't understand those, and sometimes people have a mark.
You are in very fine company. You're in very fine company. So 2 things. That is being dropped in the new version.
Right.
Yeah.
And it is because, yes, it is, the attorney who drafted those options thought it was a great idea and still thinks it's a good idea. But he realizes the implementation just caused a mass of confusion, and the confusion totally outweighed any possible benefit of leaving 2 separate options. So the quick summary of the distinction between the 2 options, one of them is that the 5A2 warranties shall continue to apply to everything in that inspection report except for items for which a repair or credit is specified herein. What that could mean to you if you're on the seller side, what that could mean is the buyer had their home inspection. The home inspection revealed various defects, some of which were 5A2 items. The buyer then served a notice under the inspection contingency asking for all the items that they wanted resolved. And let's just say that there were some 5A2 items that were so minor they didn't ask for them. If you check that post-inspection agreement option that says that 5A2 shall apply to everything in the inspection report except the items for which a repair or a credit was specified, you could potentially on the seller's side of the transaction get hit up with a 5A2 notice informing you have an obligation to make additional repairs right up until closing, even though the items being requested were items that the buyer's home inspection revealed 3 weeks earlier. In other words, even though this would never be the intention, it certainly wasn't the intention of the drafters of that language that it be used as an ambush tactic on the part of buyers against unsuspecting sellers, but as a practical consequence, that is what it leaves the sellers open to, which is a buyer going back to the inspection report and stuff that they had an opportunity to make an issue of much earlier in the process, chose not to make an issue of, they're going to ambush the seller with it right before closing. The other 5A2 continuation is that 5A2 warranties shall not apply to any conditions noted in the inspection report. In a nutshell, one of those options is more favorable to the seller, one more favorable to the buyers. Wiping away 5A2 for all conditions in the inspection report is clearly more favorable to the seller because it immunizes the sellers against the scenario that I just talked about a moment ago, where the buyers knew about the 5A2 items because they were disclosed in the inspection report and they decided to put them away in a Tupperware container and save it to open up the day before closing. Given that one's more buyer favorable, one's more seller favorable, in my own opinion, the one that puts it all to bed is really more in line with what what both parties expect. If they've had a home inspection and they have an inspection contingency and they've served a notice and there's been post-inspection notice negotiations and a final post-inspection agreement executed, is it not normally the intention of the parties that that post-inspection agreement should put to bed all issues that were contained in the inspection report? Yeah. I think that's the general understanding of the parties. And as a result, the new revision of the contract, the post-inspection agreement that goes with it, will have that as the only default setting. There will not be multiple options. What is that going to be? Well, I'm in my mid-30s now. I'm figuring by the time I am 53, 54,
Okay.
it should be, I'm thinking, within the next 3 months.
Oh, okay, good. Then I won't have to deal with it anymore. Hopefully.
You're not going to sell anything for 3 months.
That.
I love the way you set goals. It's awesome. But that's the answer. So honestly, because I've never seen somebody use that as an ambush tactic, I've never been on the receiving end of where somebody, that's the thing. It is so confusing and so hard to explain that if I'm on the receiving end of the one that's filled out the way I wish it weren't, I just tell my seller, I explain it to him, but I say, go ahead and sign it this way, because honestly, I'm going to have a way harder time, and it may cost us our post-inspection agreement altogether if we try to make it go the other way, because the other party, if they don't understand it, their agent doesn't understand it, and the buyer may very well not understand it. You try to make that change, I'm going to walk right now. I am not letting you deprive me of my 5A2 rights. Well, they're not understanding it correctly. And it doesn't mean that they're taking the house totally as is. If the air conditioning system operated at the time of the home inspection and it was noted, that was the condition as of the inspection, and it's noted to be a normal working condition, and then it does not work at the final walkthrough, it is still warranted. So it doesn't mean that everything the inspector looked at is off the table. It just means the condition as noted in the inspection report is off the table. So if it changes, something that worked changes to not working at the final walkthrough, it's still completely fair game. But again, just be very cautious if you're trying to explain to the other, oh no you didn't, because I'm here to tell you, that's not going to win you any friends, and it's probably not going to get you the post-inspection agreement any more effectively. Just a suggestion. That's one of those where even as much as I would like to impress upon the other party, listen, you idiot, you don't understand. Even I know that's not going to get, the end result is get the stupid thing under a post-inspection agreement, or else you have no contract. So then you have to weigh the practical advantage of, if I've never been ambushed in my entire career by somebody misusing that provision as an ambush tactic, it's probably not worth arguing over if it's going to cause confusion. It's a very good question, though. One that I think will disappear here shortly. Okay, so here's the other post-inspection agreement issue that comes up frequently. How many of you have had occasion to use something that was not the official MLS post-inspection agreement document as your post-inspection agreement? Yeah, so it happens some of the time. And somebody give me an example of what that looks like if you're not using the MLS post-inspection agreement. Pete?
I just reproduced the verbiage off the post-inspection agreement because I had a couple occasions where I had a lot of stuff to ask for.
Oh, you were just reformatting so you had more room to fill in blanks. Yeah, so you were still using no, it doesn't count. You're still using the MLS form. I've done that too. If all I need to do is add more blanks so I can describe in detail. Has somebody used something that's altogether not that form?
I've just had them do an email of what they're requesting
And then what makes it into the final agreement?
when they go sign it.
Okay, so that is the example I want to discuss briefly. Because that's, Fred, what was yours?
Well, this might be similar to that, and this is, from a prominent attorney on this whole subject, is simply taking the inspection, noting what is requested for repairs, just a cover letter, see attached inspection, noting repairs, inspection, signature, and all of those.
And then what makes it the final agreement? What makes it?
Both signatures.
Okay, so that's what I want to discuss briefly. Because, no, it's not that it's tacky. And there are some attorneys that hate that post-inspection agreement form. Richard Joy knows that there are attorneys that dislike it. She's not boycotting. She informed me she had a pre-existing appointment. So some attorneys have specifically recommended against using the MLS form, while others use it. And from our standpoint, the MLS form is officially in common usage, and so it's okay for us to use that. If you're not using it, it becomes a little sketchier. So to give you a very quick contract law beginner's lesson on the alternative, you have to understand that for it to be a fully executed agreement, the parties have to have agreed to exactly the same thing and have that be, for our purposes, evidenced in writing, because the contract requires that the post-inspection agreement be in writing. Potentially a chain of emails, potentially, would satisfy that requirement of being something that's in writing. But the deal is, to have it be fully, to a contract or an agreement like that to be fully executed, you have to have this, a mirror image of what was requested by the one party be exactly what was accepted by the other. And if you serve a post-inspection notice in the form of a letter making certain requests, and the seller, who's the recipient of it, simply signs it, that does not necessarily an agreement make. Because all that could be is an acknowledgement of receipt of it. So now you see their signature on it, so it obviously went in front of them at some point. They didn't say they were agreeing to it. They didn't say they were fixing it. So the agreement has to be very, very clear that they agreed to exactly what was asked. And so if you're doing something like that, at a minimum, you need a one-sentence acceptance that's very, very clear. We agree to do all of the above requested repairs, signed Mr. and Mrs. Seller. Or we agree to the above, we agree to all of the requests listed above, signed Mr. and Mrs. Seller, dated. But without that one sentence acceptance, making clear that exactly what was requested of them above is what they are agreeing to do, then it arguably is not a proper agreement.
Both signatures on there?
Oh yeah, because otherwise it's just, obviously the party who served the notice signed it. Here's what we're asking for, signed, signed. But if the seller signed it, it could be interpreted as merely a signature that not that I've had any experience with this, but when the officer makes me sign the traffic citation, they make sure that you know it's not an acknowledgement of guilt. You're merely signing to acknowledge that you've received the citation. So if I were to make an analogy, that would be one that I might use because I've had a friend who's had some tickets. So that's how that could be interpreted.
Right.
So the other thing to be aware of is that acceptance sentence isn't going to cut it if the notice gave the seller multiple choices. So an example would be, we ask that you, here are the unacceptable conditions, and we have a list of them, or we reference the item numbers in the attached inspection report. And then the letter concludes by saying, we request that you repair these in a workmanlike manner prior to closing, or in the alternative, we would accept a reasonable closing cost credit. No, because if they say yes, it's like, well, they didn't agree to anything in particular. It was multiple choices. So be aware of that. I'm not going to be too worried if you have your client, if the client writes it, tell them put in one sentence that says, I agree to do exactly. Don't give them the exact wording, but have them write in a one-sentence acceptance of that request and then sign and date. That doesn't worry me too much, but be aware that that won't cut it if it was, yes, I'll do it, but what I agreed to do is not clear because what was asked of me was multiple choice question. Okay? And that goes back to get attorney input earlier rather than later. So it's perfectly acceptable legally to do that, but the MLS form is a neater way to do it. The new form also will have in its title that it is intended to be used as a post-inspection notice, not just the agreement. Yes? I'll tell you in just a second.
I got a question going off. I mean, if you're not done with this, I'll wait.
Okay, let me answer his question then. Yeah.
Yeah, so you said the new one will have notice and agreement?
It'll be double titled as both.
Okay.
So it'll
separate.
Yeah, because one of the problems is I've put together a post-inspection notice template because the way the contract reads now, and honestly the attorneys on the contract working group don't agree with each other about it. One of them says, well, yeah, it reads that there needs to be a notice that it precedes the agreement, and so one document can't be both. And one attorney who I could swear I heard with my own ears say in the initial training 14 years ago, no, this is not intended to be used as a notice, is now saying, oh, it's perfectly fine to use as a notice. He's the one that had preached it couldn't be years ago. The new form is going to put that to bed so that it's clear it can be used as both. Doesn't mean you couldn't do a different type of notice if you wanted to, but it's clear it is designed to be used as both the first part of that process, serving the notice, and as the end part of the process, which is memorializing the agreement.
Now, because I do have two, the notice and the agreement.
Mm-hmm.
In the notice, though, you don't want to give that option of...
You can. You can. So if you want to, And if you don't, especially if you don't know what option you'd take. So if you and your client know, we would accept a closing cost credit, we're open to that. Frankly, we don't know exactly what dollar amount yet because we're still working on the amounts. So we know we need these fixed, and we know we're open to a closing cost credit in lieu of a repair. We just don't know the amount yet, and so we don't have enough information to be specific. Still perfectly legitimate as a notice. You just can't turn that notice into an agreement with a simple yes.
That also gets tricky from the standpoint of how much is the credit for if they're financing. So,
Right, because if you do get into a closing cost credit, you really, really need to do a and the new contract will have this capability built into it. That's the coolest revision being made. Because right now, the only way to get a closing cost credit in lieu of repairs pursuant to a post-inspection notice is to do a very cumbersome, slight misuse of our forms. You got to put the closing cost credit on the face of the contract, and you have to then have the face of the contract initialed by the parties. But if you don't simultaneously execute a post-inspection agreement, it's not clear that that closing cost credit that's been added to the face of the contract actually absolves the seller of liability for all of these items that were in this post-inspection notice that the seller received. And so the only way to do it properly with the current set of forms that we have is add the closing cost credit to the face of the contract, because lenders will allow for any reason or for no reason at all closing cost credits. That's all that goes on the contract, because you don't want to say, hey, memo to lender, there's a whole bunch of defects with your collateral that this is really for. So it's from the contract standpoint, just the addition of a closing cost credit. To protect the seller, it is imperative that you also have a document somewhere that makes clear that that amount of money that's in that closing cost credit on the contract is also shown here as being an amount that is in consideration of the buyer accepting as is all of these various items. You have to have all of those parts all put together. Otherwise, you may get the closing cost credit, but if there's nothing else in writing making clear that that was so that the buyer was taking these things as is, you get into another closing eve ambush, potentially, where a weaselly buyer might attempt to say, hey, we either don't have a contract, and so I'm threatening to walk because there's no post-inspection agreement, we just have this closing cost credit, or I want the closing cost credit because it's now in the contract, and I want you to repair these items because nothing ever said previously that this was in full satisfaction of these items you asked for. So, and if it makes your head spin, that's okay, because it is miserably complicated. My point is, for the next couple of months, you got to keep all those pieces in mind. But once we get the new contract revision into place, we will specifically have a spot on the face of the contract for the insertion of post-inspection closing cost credits. So it will be better because the document flow will be designed for that specific purpose.
Do you think the lender is going to then request what those repairs are and then ask for an estimate to make sure that, I mean, you know.
I can't say that the lender won't, but that part of it was done in consultation with both the head underwriter at Busey and with at least one other high-producing local lender. So multiple lenders in the local marketplace were consulted, and the attorneys are not going to claim that it's going to be perfect, but it's as good as we could do to accomplish what the goal is, and obviously no one can vouch for what a particular lender is going to demand. But it should facilitate doing this a lot better. Other questions on that subject?